You may have seen a headline that sounds terrifying. A plan in 2026 to strip U.S. citizenship from up to 200 people every month. If you are a naturalized U.S. citizen, or you have a parent or spouse who naturalized, that kind of number can hit like a punch in the stomach. So in this video, we are going to slow this down, separate fact from fear, and give you a clear, practical plan. By the end, you will know 3 things. 1. What denaturalization actually means in plain English. 2. Which situations tend to raise risk and which situations usually do not. And 3. The safest steps you can take now to protect yourself without panicking or making irreversible decisions. Here is the key point up front. Denaturalization is real, but it is not a random switch that gets flipped on ordinary citizens. It is generally a legal process, usually involving federal court, and it tends to focus on specific categories like fraud in the naturalization process or serious criminal conduct tied to how citizenship was obtained. That said, big numbers and big plans can change how aggressively cases are pursued, and that is why people are paying attention. Now, before we go further, we need to be careful with the claim itself. 200 people per month in 2026. The brief you provided frames this as something the government is preparing to implement. But unless there is a specific published policy, budget document, or agency announcement that we can point to, we have to treat the 200 per month figure as a reported claim, not a confirmed program. What we can do is explain how denaturalization works today, what would have to change for enforcement to scale up, and what risk signals you should take seriously. Because here is the part most people miss. Even when a headline is exaggerated, it often points to a real underlying trend, like more data sharing, more audits of older applications, or more focus on certain fraud patterns. So what does denaturalization mean? Denaturalization is the legal process of taking away U.S. citizenship from a person who became a citizen through naturalization. This is not about people who were born U.S. citizens. This is about naturalized citizens. And it is not the same thing as deportation. Deportation, also called removal, is a process about taking a non-citizen out of the country. Denaturalization is about undoing the naturalization itself. If denaturalization happens, then yes, it can lead to removal later, but those are separate steps. Another quick definition. Denaturalization is not the same as you losing your passport for administrative reasons or having a passport application delayed. Passport issues can happen for many reasons. Denaturalization is a specific legal action challenging the validity of the citizenship grant. Now, the next question is, how can the government do that? In general terms, there are 2 big pathways people talk about. One is tied to criminal cases and convictions connected to how citizenship was obtained. Another is a civil case, where the government goes to federal court and argues that citizenship should be revoked because the person was not eligible or because they obtained it through fraud or willful misrepresentation of a material fact. I am intentionally using broad language because the exact legal standards depend on the type of case and the facts. The important takeaway is this. For denaturalization, the government is typically not just sending you a letter saying you are not a citizen anymore. There is usually a court process. And that court process is one reason denaturalization is not common compared to the huge number of naturalizations that happen in the United States. Here is a micro hook you should remember. The bottleneck is not only legal, it is logistical. Cases require investigation, evidence, and lawyers. If you hear a big monthly number like 200, your next question should be, where would the capacity come from? And what kinds of cases would be prioritized to hit that number? Now, let us separate what we can verify in general from what is still uncertain about this 2026 claim. What we can verify as a general reality is, denaturalization exists, it has been used historically, and it is still used today in certain cases. What we cannot verify from the brief alone is whether there is a formal, published plan for 2026 with a target of 200 per month, and what agency would be formally responsible for that metric. Different agencies can play roles in investigations and litigation, but a viral claim often simplifies this into one line like, the government plans to strip citizenship from 200 people per month, without showing where that number comes from. So treat the number as a signal to pay attention, not as a guarantee that a quota exists. Here is the part most people miss. Even without a formal quota, enforcement can still increase if priorities shift, budgets increase, or data systems get better at finding inconsistencies between older records and current applications. That is why the practical steps later in this video still matter. Now, who is affected versus who is not? Let us do this carefully and calmly. Group 1. Naturalized citizens with clean histories and accurate, consistent immigration records. In general, this group is not the focus of denaturalization actions. Most naturalized citizens are never targeted, and they live normal lives with full rights. Group 2. Naturalized citizens who may have had issues in the underlying immigration process, like serious criminal conduct that was hidden, identity issues, or major fraud in the application history. This group is the one most likely to face scrutiny if the government is pursuing denaturalization aggressively. Group 3. People who are not yet citizens but are applying to naturalize. You cannot be denaturalized if you are not yet naturalized, but you can be denied citizenship or referred to enforcement if there are serious issues in your record. So the broader conversation can still affect applicants because it can change how cases are reviewed, how interviews are conducted, and what inconsistencies trigger extra questioning. Group 4. U.S. citizens by birth. Denaturalization is not about you, but birth citizens can still be affected by the climate of policy changes. For example, in how families plan travel, how mixed status households manage documents, or how people respond to misinformation. Now, the most important edge cases, because these are where confusion happens. Edge case 1. A small mistake on an old form. People hear fraud and think a typo equals losing citizenship. In most situations, a minor error that was not intentional and not material is not the same as fraud. Material generally means it matters to eligibility. But do not brush it off either. If the mistake relates to a big eligibility factor, like identity, marital status, a criminal history question, or a prior immigration violation, that can become serious. Edge case 2. Old arrests or charges that did not lead to conviction. These can still show up in background checks. They do not automatically mean denaturalization, but they can trigger questions, especially if the naturalization application answers do not match the record. Edge case 3. People who got lawful permanent residence through a family petition or employment route, where later fraud is alleged somewhere in the chain, like a marriage that the government later claims was not real. This can be complicated because the allegation can reach backward into eligibility for the green card, and then forward into eligibility for naturalization. That is why records and consistency matter. Now let us talk about why this is happening, or at least why this topic keeps coming back. There are a few drivers that are not partisan talking points, just mechanics. 1. Data matching has improved. Agencies can compare fingerprints, names, dates of birth, old A files, visa applications, and criminal databases more easily than they could years ago. 2. There are backlogs and resource constraints, and sometimes enforcement focuses on categories that are easier to prove because the paperwork trail is clear. 3. Public attention spikes whenever there is a national security concern, a high-profile fraud case, or a political push to look tough on immigration. Even if you ignore the politics, the bureaucracy responds to incentives, measurable case outcomes, clear evidence, and high-impact narratives. Here is a bridge hook. If you understand what makes a case easy to bring, you understand who is most at risk. The cases that are often easiest to pursue are the ones with clear documentary inconsistency. For example, an application that answered no to a key question, and later the government can show the correct answer was yes, and that yes would have changed the decision. Again, I am speaking generally, not making accusations about any viewer. Now, about the 200 per month number. Why does that matter? Because scale changes behavior. If denaturalization goes from rare to routine, 3 things can happen. First, more people may receive requests for evidence, more interviews may get intense, and more cases may be referred for deeper review. Second, the fear factor spreads beyond the actual target group, and that can cause real harm. People stop traveling, People delay applying for benefits they are eligible for. People get scammed by fake lawyers. Third, systems can get overloaded, and that can slow down everything else, including citizenship processing for ordinary applicants. But for $200 per month to be realistic, there would have to be some combination of increased staffing, a specific enforcement initiative, streamlined selection of cases, and coordination between investigators and litigators. If any one of those pieces is missing, the number may be more of a rhetorical alarm bell than an operational plan. Myth versus reality time. Myth. The government can take away your naturalized citizenship instantly with a letter, and you have no rights. Reality. Denaturalization typically involves legal procedures and due process. People have the right to contest allegations. The government generally has to prove its case under the applicable standard in court. Myth. If you ever made any mistake on any immigration form, you are going to lose citizenship. Reality. Not all mistakes are treated the same. Intent, materiality, and eligibility impact matter a lot. Myth. Denaturalization is only about national security cases. Reality. While national security and serious crimes get attention, denaturalization actions can also involve fraud allegations that are not framed as national security. The common thread is usually the claim that citizenship was not lawfully obtained. Now let us get concrete about real-world consequences, because this is where anxiety becomes practical. If someone is targeted for denaturalization, it can affect passport renewal, it can affect travel planning, it can affect employment if a case creates uncertainty, and it can put enormous stress on families. Even before anything is decided, the process itself can be punishing. Legal costs, time, and fear. And for people who are not targeted but are hearing scary headlines, the consequences can be different but still real. People stop applying for citizenship even though they are eligible, or they delay filing an N-400 because they worry they will be scrutinized. That can actually increase risk in some cases, because long delays can lead to missing deadlines for other benefits or staying in uncertainty longer than necessary. Here is the key. You should not make big life decisions based on a viral claim. You should make decisions based on your facts and verified information. Let me give you 2 example scenarios to show how these issues can play out. Example Scenario 1. Maria naturalized 12 years ago. She is renewing her passport and planning an international trip. A family member sends her a video about 200 denaturalizations per month, and she panics because she remembers that on her green card application long ago, she used a slightly different version of her name. What should Maria do? The calm approach is, gather records, check consistency, and if there is a real discrepancy, get qualified help to understand it. A name variation is often explainable, especially if it is consistent with cultural naming or translations. Panic does not help, but records do. Example Scenario 2. Ahmed naturalized several years after a criminal case. He disclosed the case at his naturalization interview as he understood it, but the court disposition paperwork was complicated. Years later, he hears denaturalization news and worries his file may not match the official court records. In this scenario, the practical step is to obtain the certified court disposition and his immigration filings and confirm the answers he gave match the official record. If there is a mismatch, do not guess or try to fix it informally. This is where a qualified immigration attorney is important, because how you correct or clarify a record depends on the details. Now we get to the most important segment, what to do now. Not legal advice, just a practical safety checklist that helps most people reduce risk and reduce anxiety. Do this first. Build your personal immigration file. Collect copies of your N-400, your naturalization certificate, your green card history if you have it, and key supporting documents that were submitted. If you do not have copies, request them from your prior attorney if you used one. Do this next. Pull your criminal history records if you ever had arrests, charges, or court cases, even if they were dismissed. You want the official disposition, not a memory of what happened. Do this. Check your information for consistency. Names, dates, addresses, marriage and divorce dates, children, travel history, employment history. You are not looking for perfection. You are looking for big discrepancies that could be misunderstood. Do this. Use official channels to monitor updates. For example, official USCIS pages, the Department of Justice press releases for major cases, and official statements from agencies. Avoid relying on screenshots and clipped videos without sources. Do this. Protect yourself from scams. If someone tells you they can guarantee to protect your citizenship for a fee, or they claim they have inside access, that is a red flag. If you need help, verify that the person is a licensed attorney or an accredited representative. Now avoid this. Do not lie or guess on any immigration form. If you do not know an exact date, follow the form instructions for estimates or explanations. Avoid this. Do not destroy documents or try to rewrite history. That can create bigger problems. Avoid this. Do not change travel plans solely due to rumors. If you have a specific concern, verify it with official guidance or qualified counsel. Avoid this. Do not ignore official mail. Many problems get worse because people miss deadlines to respond. Here is a quick, if you are in X group, do Y segment. If you are a naturalized citizen who had any prior name changes, multiple passports from another country in the past, or complex immigration history, do a proactive file review. Get your own copies of filings and key identity documents so you are not scrambling later. If you are applying for citizenship now and you have any criminal history or prior immigration violations, do not rely on internet summaries. Get the exact court dispositions and consider a consultation with a qualified attorney before filing so your application is accurate and complete. Another myth versus reality, because this one causes panic. Myth: if your citizenship is challenged, you automatically lose all rights immediately. Reality: legal processes take time, and you typically retain rights unless and until a court order changes your status. But also reality: the process is serious, and you should respond quickly and carefully because missing deadlines can create avoidable harm. Now, what could happen next going into 2026? Here are the watch points that matter without speculation. Watch point 1. Official guidance and public messaging. If agencies publicly prioritize denaturalization, you may see updates to web pages, training, or public statements. Watch point 2. Budgets and staffing. If resources increase for investigations and litigation, capacity could rise. Watch point 3. Data initiative. If there is expanded data sharing between agencies, that can increase identification of inconsistencies. Watch point 4. Court decisions. If there are major rulings on the standards or procedures for denaturalization, that can change how cases are brought. Watch point 5. Demand surges. When scary news spreads, more people file for citizenship quickly, and that can create backlogs and slower processing, which then creates more anxiety. Here is the small detail that changes everything. The difference between rumors and real risk is documentation. If you can document your history clearly, you reduce the chance that a misunderstanding becomes a problem. If you cannot, your first job is to build that documentation. Let us do a final calm recap. 1. Denaturalization is a real legal process that applies to naturalized citizens, but it is not a random administrative switch. 2. The reported 200 per month number for 2026 should be treated cautiously unless supported by official documents, but it signals that more people may be worried and more scrutiny may happen in certain case types. 3. Most naturalized citizens are not the target, but people with serious fraud allegations or major inconsistencies are higher risk. 4. The real-world impacts are often felt through stress, travel planning, job stability, and family security, even before any court decision. 5. The safest action today is a records-first approach. Gather filings, confirm court dispositions, keep your information consistent, and monitor official sources. If you take nothing else from this video, take this. Do not panic, and do not make irreversible decisions based on viral claims. Get your documents in order and verify information through official sources. If you want, tell me in the comments which category you are in: already naturalized, applying soon, or helping a family member. And if you found this breakdown useful, subscribe and turn on notifications, because if any verified official guidance emerges about denaturalization priorities in 2026, I will summarize what changed, who was affected, and what to do next in plain English.